Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
I want to thank you for joining us again. And thank you to those people who sent some questions to the program. We want to let you know that we have received them and that we'll be looking at hopefully answering your questions in the future. The questions involving conservatorships, whether or not to do a will or a trust. We also had a question regarding a homeowners association, which is outside of my area, but we can certainly do some research on it. And there was one question regarding the appointment of federal judges, and of course that is different from state judges. But we're going to talk about those again in a future program. Today's topic is driving under the influence.
DUIs.
And also known as 502s, drunk driving, and periodically deuce. Bob, DUIs, as we will refer to them, is probably one of the more prominent cases that we see.
I really think so, particularly for the average everyday citizen. You don't know if you're going to end up in that position.
It's confusing sometimes when people get arrested for a DUI and they see that there are two charges that show up.
You know, a lot of people, that's their immediate reaction. How come I got charged twice for the same thing?
Okay. The explanation is this. We'll talk about Vehicle Code Section 23152A and 152B. 23152A is the way we typically say it, is driving a vehicle. Now, it's either a car or a vessel, meaning a boat, and the officer or certainly the DA, the court, feels that you may have been under the influence of drugs and or alcohol, either one. No alcohol is actually necessary if drugs are involved, even if a prescription medication. And the key to that, why it differs from driving under influence of alcohol, the second section that you'll talk about, is that the prosecutor is going to have to show that his or her, that's the person arrested's, mental or physical abilities are so impaired that he or she is no longer able to drive a vehicle or a vessel with the caution of a sober person using ordinary care under similar circumstances. We'll talk about that a little bit more. What is the one that we see most often that people are faced with, Bob? The B section.
The B section, the alcohol section. And also we see sometimes where people have a prescription and they will drink not knowing it's going to aggravate it.
That's the A count.
That's the A count, but we do see the B section the most. People go out and have a glass of wine with dinner and want to appreciate if they have a couple of glasses within an hour what it's going to do.
And that's where we see blood alcohol in excess of 0.08, correct?
Right, because their blood alcohol is going to rise over time.
And typically what we refer to is, in the official terms, is blood alcohol level. I can't get that out. But realistically what it is a alcoholic beverage, and we're measuring, or law enforcement is measuring the blood alcohol level, and it's percent weight per volume. I forget exactly how it is. We just say BA. Now, the highest I've seen, by the way, personally, given my law enforcement background, is a 0.43, and that person was actually walking kind of and talking.
Kind of.
But most people, the trouble that they get into is the 0.08. And as you pointed out, maybe a couple of glasses of wine, whether wine tasting or going out to dinner, maybe a small amount of hard liquor, which of course has a higher alcohol percentage, but that's the one we see most often, correct?
That's true. And the question is, well, if you do have that .08 or higher, and that's going to depend on your body weight and your size and your tolerance and so forth, but you know that impairment is presumed at that point.
If you're .08 or higher, correct?
Yes.
Now, differing from the A count, or the drugs and or alcohol, you don't have to necessarily exhibit any particular driving pattern, which means that if you're sitting at a stop sign and somebody rear ends you, and the law enforcement officers get there, you absolutely did nothing wrong, but you're behind the wheel, that's enough, you're driving, and your blood alcohol level is .08. You don't have to be at fault.
So all you have to do is be driving the car. You don't have to be weaving or anything like that.
Nothing. Now, the A count, that differs because that's where the physical or mental impairment comes in. There has to be some demonstration that you're actually impaired. But for the B count, there doesn't have to be any impairment visual to the officer. No weaving, nothing, as you pointed out. So it is completely different. What's a wet reckless?
Well, wet reckless, we have reckless driving. That's usually used in plea negotiations in DUIs where the blood is real close to a .08.
Okay. It's different from a reckless driving.
True. It is quite. It's statutorily.
Now, sometimes some DAs will actually file a wet reckless, and that's section 23103, and we do it pursuant to 23103.5. A lot of legal stuff here. But basically, a person who drives on a vehicle on a highway in a willful or wanton disregard for the safety of persons or property is guilty of reckless driving. Now, that's the actual reckless driving that I just quoted there. But that is mostly, as you pointed out, a plea bargaining issue where a person, maybe their driving isn't bad, but they're right at a .08, and maybe even if their driving is bad, but they're a .07, the case may settle out for a wet reckless, which is a lesser fine, lesser penalties.
Let's say they have a wet reckless, Steve. If you have so many DUIs within a time period, your punishment's going to escalate. Is this wet reckless going to count against somebody?
Excellent point. One of the laws in California says that if you plead to a wet reckless in lieu of a driving under the influence, that wet reckless charge may be used against you in the future for showing a prior conviction of alcohol-related driving, which does enhance the penalties and could cause you to do extended jail time, but certainly can be used in future charging if you get arrested for the same thing again in the future. Now, we talked briefly about reckless driving. One of the things about reckless driving, by the way, a lot of people don't know. No, we're not talking about alcohol related. We're just talking about reckless driving. You can actually get a reckless driving in a parking lot.
That's off the street, not on the public highway. So any property really not on the public highway, am I correct?
Correct.
Not even a parking lot. It could be a driveway or somebody's field.
You can get arrested for drunk driving on your own property.
Interesting. Okay.
We've had cases where people got arrested for driving under the influence of alcohol on an ATV. And I'm also aware of one DUI arrest was the person was on a bicycle. Bicycle is a vehicle, motorcycle certainly is, but if it's a vehicle or a vessel, you can be arrested for the B count. Now the A count, to my recollection, does not apply to, the B count doesn't apply to vessels, just the A count. That's where the drugs and or alcohol. And you mentioned medications. A lot of people feel that, geez, I'm taking these antidepressants, and I just had a little sip of alcohol. My blood alcohol is not over .08. How can I be convicted?
There's a thing called a synergetic effect. And that means your medication is going to interact with that alcohol, and it's going to escalate the level of the blood alcohol.
But the alcohol is not necessary, correct? And if a person's taking certain medications, they can still be under the influence of drugs and be in violation of law, even without the alcohol, correct?
No, that's absolutely correct, Steve. In fact, I heard of one case where involving marijuana, and the question was, the person was recommended marijuana, not prescribed it, you recommended it. And the question was, what was his tolerance level?
That's an interesting issue in and of itself, the issue of driving under the influence of marijuana. In most cases, like alcohol, you have 0.08. We get into the issue of quantitative versus qualitative analysis. I'm not going to go into it, but in short, we know that certain levels of alcohol do affect a person to drive, but those same levels have not been established for medications you've been prescribed or marijuana. If you ever get arrested, certainly talk to a lawyer. Definitely talk to your pharmacist or a doctor about whether or not you should drive on your medications, because you could find yourself in trouble.
One of the things I wanted to say, Steve, about the reckless driving, whether it be a dry or a wet, the person has to present a substantial and unjustifiable risk of harm. And he or she has to intentionally know that she's presenting that.
That's the difference between a regular reckless and a wet reckless. With reckless, you're doing an act that is willful and wanton, and you essentially understand that there's a potential risk. Under a wet reckless, they don't need to show a willful and wanton disregard for other people. Where we see this is people driving crazy on the street, weaving in and out of traffic, no alcohol, but they're definitely endangering people. Someone could be in a parking lot doing Brodies, and other people are standing around and watching. And the driver's creating a risk to those watchers, the observers. That could be reckless driving. In any of these, I don't care whether it's wet reckless, dry reckless, driving under the influence of alcohol, wait till you get your next insurance bill. And we'll talk in another program about accidents, and with these type of records, you've got a real problem.
I think the people should know that a wet reckless is going to count as a DUI type on their insurance situation.
Absolutely. And from what I understand, and I don't know, that they could charge you higher rates for up to 7 years.
Wow.
It's a long time.
Yeah.
Person ends up getting convicted for a DUI, whether it's A section or the B section. What happens to them?
Well, it depends on if that's their first or their second or their third. But on the first offense, you're usually going to end up with probation and 2 days in county jail. And a lot of times people are arrested and they're kept over midnight. They're going to get that 2 days credit, or it could be community service. And you're going to end up with about 3 to 5 years probation.
Now, one of the technicalities we get into, the law actually says 48 hours continuous in jail. But interpretations of the law have said that if you're booked in jail 1 minute before midnight, released 1 minute after midnight, in other words, a total of 2 minutes, that may in fact count for those 2 days. And that Calaveras County in the past has followed the 48-hour rule, but sometimes, and I think that they're now following the 2-day rule. Any part of a day is a day.
I have an interesting question. Do you mind interrupting? I was just thinking, with the new 50%, where in jails in the local time they're doing 50%, do they have to do the 2 days? I was just curious about that.
Actually,
I don't know the answer.
It's a technical question, and it doesn't kick in, because I believe it's 4 days minimum before they start counting additional days. Again, that's another topic. But no. Now, a person does not have to accept that 3 to 5 years probation. Calaveras is fairly standard at 5 years of probation after you've been convicted of a DUI. However, if you just say, I don't want that probation, you're going to do at least 96 hours in jail, and I can almost guarantee you're going to do that in jail. The fine is higher, and because the Department of Motor Vehicles is a separate entity from the courts, you're still going to be required to do a DUI class.
That's one thing we missed. Even on the first offense, you're going to be required to do a DUI offense.
Well, that's absolutely correct, is that, and that you will do the DUI class. And the fines, by the way, for DUI are about $2,000. I'll talk a little bit more about that later.
That's before they raise your insurance rates.
I'm just talking about the court fines. I can't try to estimate, because I've never asked any of my former clients what happened as far as their insurance, other than the fact I tell them up front it's going to go up. But how bad did their insurance go up? How long did it last? But certainly it does cause some problems. And if you don't have insurance, you're going to have to get some. And you're looking at having a high-risk policy at that point, and they're quite expensive. Also, with a first-time conviction, you've got DUI school. Okay? And that for first offense may be as much as from minimum of 3 months to a maximum of 9 months. And that depends on your blood alcohol level. And under the law, if you're over a 0.15 or over a 0.20, the court can require you to go to at least a 9-month class. And you do pay for those. And they get their money pretty much up front. There is a sliding scale issue that does come into play. We won't get into that because I don't know all of the technicalities of how much you have to make before they consider that. But what happens if it's a second offense? How long do you end up going to school in, Bob?
About 18 to 30 months, Steve.
And that's also contingent on whatever the blood alcohol level was?
That's right, yes.
But isn't there a minimum on that?
A minimum of 18 months. Or 10.
That's 10 days in
10 days in jail. I thought you were talking about the classes. Yeah. Actually, there's a minimum of 10 days in jail.
Okay. And then third offense, now you're looking at a mandatory 18 months of DUI classes.
And 120 days in jail, minimum.
That's the minimum.
That's right.
So if you've got a third offense, no matter what plea bargaining is going to happen, perhaps in your case, you're going to do at least 120 days in jail.
That's correct. We're not talking what they commonly refer to as in the vernacular as a split, but you're going to do that, not part of that community service, but in jail.
And getting back to the question you asked earlier, in this case, that's when that 50% credit's going to kick in, that you're only going to do 60 actual days. But let's face it, 60 days of unemployment, unless you're already unemployed, and you're going to be out of work. If you're in jail, I don't care if it's 60 days, 120 days. And as I understand, and I haven't verified this, that if you're getting unemployment and you go to jail, that stops.
I've heard that too. I haven't verified it, but I've heard it.
Yeah.
Now, I just want to, we've been talking about the DUI classes and the first-time, second-time offender classes. Just what are they? I mean, who gives those classes? How does people sign up for them?
In Calaveras County, it's under behavioral health. I didn't bring their phone number with me, but trust me, when you go to court, they're going to tell you who to contact. They're going to, in fact, in Calaveras County, they'll actually give you time frames that when you've got to do certain things, and if you don't do it, the court, and this gets under probation issues, can actually give you more jail time for not doing what the court has ordered. So while you may get 2 days at the outset, if you don't go to behavioral health, you don't go to probation, you don't pay your fines, the court can actually give you additional jail time separate and apart from what you got at the outset. So you got to pay attention to whatever the court tells you. But in Calaveras County, it's behavioral health.
And they're going to know if you didn't go to the class.
I believe they get a list from the court of who's supposed to be showing up. And I've seen letters where they actually report these people did not show. There's a lot of cross-checks in the system. Let's back up a little bit. Okay. We've been talking about the punishments and so forth. What if a person gets stopped for DUI? Now, some defense attorneys, criminal defense attorneys, have advice for people who might get arrested for DUI.
Well, I think the first thing is to be cooperative with law enforcement up to a certain point. You can tell if he's stopping you because of DUI. You can usually sense that, but be cooperative up to a certain point. You were law enforcement, so you probably ran into that.
Bob, we were still using horses and buggies, okay? Well, actually not quite true. The law has changed. In 1990, the law went from 0.10 to 0.08. Some other laws have taken effect, and certainly there's some commonality between what I did, my law enforcement background, versus what the law is today. But from a defense perspective, a lot of attorneys' advice is, as you said, be cooperative, be polite, and Do you volunteer to do all of their tests and stuff?
No, what they call the field sobriety tests, you don't have to do those, and you can refuse to do those. There are certain exceptions, maybe if you're on probation or something on the PAS. I'll let you talk a little bit about the PAS. How about that?
Okay. Bob is correct. Defense attorneys do give the advice, if you're stopped for DUI and the officer said, please step out, I'd like you to perform some tests, you are not required to answer the officer's questions about where you've been, where you're going to, how much you've had to drink, how much you've had to sleep, whether or not you're injured, and there's a number of different questions. We call them pre-field sobriety questions. The position a lot of defense attorneys take is that those questions are designed to eliminate any defenses that you may have. So you can say, officer, I actually don't choose to take any of your, or answer any of your questions, and I don't want to take any field sobriety tests. But if you're going to arrest me, I would like a blood test.
Well, there's 3 tests you can take, a urine, breath, or blood. Why blood?
Well, let's back up.
Okay.
First of all, urine test is pretty much gone. Most people couldn't complete it anyway. That did exist when I was in law enforcement. What was required is first the officer standing right there, which was a little awkward when you had to find a matron in those days when it was a female officer, and I presume they'd do the same today. The person has to completely void their bladder. The officer has to wait 20 minutes, and the person has to now give a sample. That's the sample that is actually used for testing, and I will get into the biology of why that is necessary. But so many people had difficulty with it that it just pretty much is phased out. So you've got a choice now of a breath test or a blood test. Most defense attorneys that I've spoke to have suggested the blood test because of all of the tests, it is the most accurate.
I have a quick question. What's a forced draw?
A forced draw is, particularly we see this in felony cases. In other words, there's an accident, somebody's been injured other than the driver. The officers can literally force the person, hold them down, and take a blood sample. And that is available under the law. The officers can do that. And I know the officers dislike having to do it, but there are times when the facts of the case, like an injury, accident, they really have to have some evidence that the person was or was not under the influence of alcohol, so they can do a forced blood draw.
Can you refuse these tests?
Absolutely, you can refuse. Let me tell you what happens when you refuse. If you tell the officer, I'm not taking any tests, your license will be suspended automatically for a period of 12 months. No ifs, ands, or buts. It's not the court that's going to do it. It's the Department of Motor Vehicles. So if you say you can arrest me, but I'm not taking any tests, in other words, you don't say I want a blood test, you're going to lose your license. That's the end of that story. Even if the district attorney or the court throws out the case, decides not to prosecute, and the court dismisses it for lack of evidence, DMV doesn't care. You're going to lose your license for 12 months. And that's because of what we call the Implied Consent Law. Do you remember taking your driver's license, Bob?
That's
your test?
That's right. When you do that, you impliedly consent to, I will take one of these tests. You're saying you will do that.
Absolutely. Even if you don't have a driver's license, the implied consent law is still there. What happens is they can't suspend your license, but they certainly can suspend your privilege to drive for a year. So
either way, you're not going to drive.
Well, you're not supposed to drive.
Not supposed to drive.
If you get caught driving on a suspended license, there are a lot more penalties than you want to deal with right now.
Just off the bat, that's a mandatory 10 days, as I understand.
If it's alcohol related. In other words, if the conviction or the refusal is alcohol related, 10 days. If it's your license is suspended for other reasons, then it's 5 days. And that's usually per violation. So in other words, if you've got 3 or 4 driving in suspended licenses, then you're looking at multiples of 10, 20, 30, well, actually goes 10, 20, 40, 80. That's how it's multiplied up. Now, we also often hear of PAS, Preliminary Alcohol Screening Device, and we see that when the officer is doing the field sobriety test. It's a field sobriety test, isn't it, Bob?
It is in a sense, it's a machine that they take out that they breathe into, but it's not as accurate as the test done back at the police station, so to speak, or CHP office.
Correct. And in fact, the officer, in asking you to blow into the machine, will tell you right up front, you still will have to give a blood or a breath test, the official test. That the field sobriety test, the preliminary alcohol screening device, or PAS, does not satisfy the implied consent law. And having talked to a lot of different experts, they argue as to the accuracy of it and why it's not consistent with what you would get on them. For instance, they drew your blood and actually tested your blood alcohol level. So if you say, I'll take the first test, the one out on the street, don't anticipate that that's going to count for anything in the field sobriety test, which it is. And if you say, I already took one, I'm not going to take the breath or the blood test that you're now offering, that will be a refusal.
One quick item, if you have a blood test, and you can ask your attorney to get a sample of that, particularly if it's close to the limit, 0.08 for a retest. Am I correct?
Absolutely correct. And it gets a little expensive, but it certainly can be well worth it. If you talk to an attorney, you let them know that you took a blood test, and they will go from there. Now, let me throw in one quick admonishment. If you're on probation for a DUI, and the officer tells you to blow into the PAS machine, you absolutely better do it. Because if you refuse to do that, the preliminary alcohol screening device, it is a 1-year suspension. That's different from people who are not on probation for DUI.
What if you don't have any alcohol in your system? Do you still have to do that?
If you're on probation, absolutely. You have to play these things by ear. You don't just arbitrarily say, officer, I'm not going to answer your questions. If you haven't been drinking, not taking any medication, you may want to cooperate. You still may end up going to jail if the officer thinks you're under the influence, but
that's the attitude test, right?
Correct. Now, a lot of people say, well, how much is the court going to fine me? Well, it's expensive. Calaveras County is getting real close to $2,000. But a lot of people say, well, that's just going to go to the officers, but that's not true. In fact, there are penalty assessments, there are criminal surcharges, there are program fees for alcohol, restitution fine fee, court security fees, and you add them all up, that's going to come to very close to your $2,000. And then everybody says, well, what's this penalty assessment thing? Well, it's about 270% of the base fine. The base fine is $390, and that can go anywhere from restitution fund, peace officers training, driver's education training, public defender and prosecutor training, all kinds of different areas. And that's true with all fines, by the way, that they go to different directions.
It's used to support our system.
Absolutely. When it comes to DUIs, what is the most important thing to remember, Bob?
Have a designated driver.
Or don't drink and drive. There's been a trend in California that DUIs have been on the increase. Just to give you an idea that every year that California has approximately 200,000 DUI arrests. Now, one of the statistics I looked at was actually a 1997 statistic has shown a decrease in DUIs in California since the .08 law came in 1990. But the trends that I've seen don't necessarily support that. We also know that in Calaveras County that there last year were 313 DUI arrests. About 5 of those resulted, I believe, in deaths, and I forget how many injuries. Don't drink and drive. Thank you for joining us today.
Thank you.